Unfortunately, even with a good operating agreement, sometimes disputes will still happen between the members of an LLC. And so a good operating agreement will plan for dispute resolution. If nothing else, the operating agreement can set the ground rules for how we'll go about resolving any disputes that do come up, and preferably how we can reach a resolution well before this ends up in court. I'd like to use mandatory mediation because it can save the members of the LLC tens of thousands of dollars in legal fees and hundreds of hours away from the business. And that's assuming, of course, that everybody can set aside the emotional baggage and really get down to the business of how do we go our separate ways. But failing a peaceful resolution, the operating agreement should also dictate, okay, what court are we going to use for any litigation among the business partners? It should spell out the fact that the loser should pay for the winner's legal fees in the event of litigation. This is not the default rule, so don't assume that just because you go to court and win a case, you're going to get your attorney's fees paid for. Contrary to popular belief, without that provision, everyone will almost certainly pay their own legal fees, and fights between business partners are very much like divorce cases. The only real winners are the attorneys on both sides of the dispute. So that's just another reason why you need to have a well-drafted, written and signed operating agreement. Start addressing what could happen in the event of a dispute now instead of after it comes up.